Request for admissions when you're sued for debt. Brought to you by Kenneth Chabert at yourlegalagup.com. Your advantage if you're being sued by debt collectors. Requests for admissions were designed to simplify litigation. They rarely work as intended, though. They function more as a trap for the careless than anything else. If you're being sued for debt, you should be aware of them. Both because the requests can be lethal to you if you ignore them, and because they are occasionally a gambit worth trying. Requests for admissions are, very simply, a request to the other side to admit certain things. And these things can be facts or even legal conclusions. You must respond within a specified time period. That's usually 30 days, but check your rules of civil procedure and make sure. If you don't answer them, they're considered admitted. If the debt collectors send you a set, you will notice that they request you to admit every single aspect of the case against you. They're hoping you'll forget to respond or that you just won't for some reason. If you do fail to respond, they'll file a motion for summary judgment and try to get the whole case decided on that basis. That would make things pretty easy for them, and to try to make it more likely, the lawyer for the debt collector may very well pull a trick to try to intimidate you. He or she will attach an affidavit form to the request, implying that your responses to the requests must be under oath. In my view, this is an unfair debt collection practice under the Fair Debt Collection Practices Act. Requests for admissions are not made under oath, normally. To imply that they are is an attempt to intimidate a party, that's you, into admitting things. Or to add to the general stress and difficulty of responding at all, with the increased possibility of a failure to respond at all. So I believe that people receiving this sort of request for admissions, that is, with an affidavit attached, should strongly consider amending their answer to include a counterclaim under the FDCPA alleging that. So to look at it from a slightly different angle, what happens if you deny something that you should have admitted? There is a possible sanction for wrongly denying an admission requested of you, and that is that the court could require you to pay the other side's attorney's fees for the time spent trying to prove something that was sufficiently obvious that you should have admitted it. Proving how much time that took is very difficult and annoying to the other lawyer, even if the court lets you do it. I'm not saying it couldn't be done, but I'm not personally aware of any court under any circumstances that has ever awarded that sanction to anybody. I'm sure it's happened. But is it a significant risk? You decide. Most lawyers I know find some reason, just about any reason, to object or to deny them all. Send some requests to the debt collector, and you'll see what I mean. There is a type of request for admission that could be useful, though, and this is a request that certain documents were created and sent by the debt collector. If you received a letter, for example, signed by John Debt Collector, dated August 15th, 2009, you might attach a copy of that to your request for admission and ask them to admit that 1. The attached letter is a true and correct copy of a letter sent by John Collector. 2. It was sent on or about August 15th, 2009. 3. That John Collector was an employee of the debt collector. And 4, that John Collector sent the attached letter in the normal course of his employment with debt collector. And 5, that John Collector sent the attached letter in an attempt to collect a debt. These are all separate requests for admissions, all separately numbered. You can repeat that process for any documents that you may have received. Be sure to mark each one separately and distinctively so that they know which ones you're talking about and refer to them by, Exhibit A, B, or whatever. If you sent some sort of notice, you may ask them to admit that they received the notice. And what you do there is you attach the notice, a copy of it, and you ask them to admit that they received it on or about the date that you sent it. They'll probably deny every fact that you ask them to admit in a request for admissions, but maybe they'll admit the documents. Or maybe they'll forget to answer them at all, and that's why you also want to be sure to ask them to admit that each of their allegations regarding you owing them money is not true. And if they forget to respond, you can get the case dismissed. You'd file a motion for summary judgment, so take a look at the videos on that. And this is just the way the game is sometimes played. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.